Hi, everyone. Did you know the state can't prove your BAC at the time of driving? This is Christina Williams with Just Criminal Law.
And this is David Mann, legal storytelling specialist. I always thought that they could prove your blood alcohol content right there and prove it completely, but you're saying they can't?
Right. I have a case right now where a client was camping, had a couple beers, and realized he forgot something at the store, so ran to the closest convenience store and had a beer in his cup holder. Now, this was a 2-lane highway, and as he was driving, an oncoming car started to swerve into his lane. Well, he took to the ditch and ended up having an accident where he suffered minor injuries. So law enforcement responded.
All right, so that's a pretty bad situation for him because it looks like he's got an open container in his car and he must have been drinking, and I'm sure a lot of assumptions were made. Is that what happened?
Right. So he was taken to the hospital, and little over a couple hours passed from the time of the accident until the officer was able to question him again. He was being seen by the doctors. And so about 2.5 hours later, the officer asks him for a blood sample, which he agrees to provide.
Okay, so at that point, he's giving a blood sample, and it's been a while. So what does that blood sample show?
He came back a 0.08%, which is the legal limit, and he was charged with a DUI.
Wow. All right, so for a lot of people, that's where the story kind of ends, and they get a DUI. They have the consequence, which is huge for that. But you're saying there's actually, if a lawyer gets involved, they can actually find that is an unprovable 0.08. Is that right?
Right. And so what we have to do then is contend with some math that the state's going to want to put into evidence, saying, if you do retrograde extrapolation, and we're talking about, how the average person eliminates alcohol, we're going to assume at the time of the accident he was as intoxicated as he was going to be that day. And people get intoxicated on a bell curve, and so as you have one beer, you might be a 0.01, and then as you have another beer or 3 beers, you become, say, a 0.05. And as you continue to drink, your blood alcohol level rises until you become as intoxicated as you're going to get. You've stopped drinking, and then you start to become sober, and your blood alcohol content lowers again. And so the state, in these type of cases, is always going to ask the jury to believe at the time of the accident or the time of the driving, the person is as intoxicated as they're going to be, and ask the jury to believe that. But it's just as reasonable and just as believable that the person was not, in fact, as intoxicated as they were going to be at the time of driving. In fact, they were as intoxicated as they were going to be after the driving. And so the defense can put on just as persuasive evidence that the person was a 0.05 or a 0.06 at the time of driving, and perhaps a higher level like a 0.10 maybe an hour after the driving, and then starts to come down to a 0.08, which is what the official result on the blood test comes back as.
So it's a matter of them saying that the person is coming down to the 0.08, and you're saying, yeah, but we don't know. It could have been that they went from down to up and ended at the 0.08 a couple hours later. So an ordinary person would not know to even bring that up, and they should probably call you to get you to do it for them, right?
Right. We definitely understand the science behind what the state's trying to put before the jury, and we can contest that blood result. If they want to get a hold of us, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.